Picture a downtown corner on a cold afternoon. A veteran detective, decades on the same beat, is doing the one thing his job is really made of, watching. And two men catch his eye. One walks down the block, pauses at a store window, peers inside, and walks back. Then the other does the same thing. Then the first again. Back and forth, past that same window, more than a dozen times. To you it might look like nothing. To a man who has spent his life reading streets, it looks like exactly one thing: they are casing that store, rehearsing a robbery. So he walks up, identifies himself, and asks their names. And when the answers come back mumbled and wrong, he does something that, in that moment, the law had never clearly said he could do. He grabs one man, spins him around, and runs his hands down the outside of his coat. His fingers hit something hard. A pistol. Loaded. No warrant. No arrest yet. Just a hunch a trained officer could put into words. Now here is the question the entire country would have to answer. Was that a legal search, or did that detective just violate the Constitution? Hold your answer, because the line they drew that day is standing between you and every officer you'll ever meet. Let's be precise about what happened, because every word of it mattered later. The officer did not have a warrant. He had not arrested anyone. He didn't have what the law calls probable cause, solid, concrete evidence that a specific crime had been committed. What he had was a pattern of behavior and 30 years of instinct telling him a stick-up was about to go down, and that these men were almost certainly armed. So he didn't wait for the crime. He stopped them on the sidewalk, and to protect himself, he patted the outside of their clothing, not a deep dig through their pockets, but a quick sweep of the surface, feeling for a weapon. On one man he felt a revolver. On another, the same. He took the guns, and those men were charged with carrying concealed weapons. Their lawyers came back with an argument that was, on paper, powerful. That pat-down, they said, was a search. The Fourth Amendment protects you from unreasonable searches, and searches are supposed to require probable cause and, usually, a warrant from a judge. This officer had neither. So the guns, they argued, were the fruit of an illegal search and should be thrown out. And they had a point, because until that day, the rules really did seem to be on their side. To feel the weight of this case, you have to understand what the Fourth Amendment was built to be. It is a wall between you and the government, a promise that the state cannot just search your body, your home, or your things on a whim. For most of American history, the key that opened that wall had one name: probable cause. Before an officer could search you, the idea went, they needed real, articulable evidence that you'd committed a crime, often enough to convince a judge to sign a warrant. That's a high bar, and it's high on purpose. It's what stops police from stopping and searching anyone they simply don't like the look of. But that high wall left a gap in the middle of everyday policing. What about the officer on the street who sees something wrong unfolding right in front of him, who doesn't have probable cause yet, but has every reason to think the man in front of him is armed and dangerous? Does he have to just stand there, exposed, and wait for a gun to come out before the law lets him act? That was the trap. On one side, your right to walk down the street without being grabbed and searched. On the other, the life of an officer who might be 60 seconds from being shot. The Supreme Court had to find a doorway in the wall, one narrow enough not to swallow your rights whole. And here is the bargain they struck, the heart of the whole case. The court agreed that a pat-down is a search, and that being stopped is a seizure. Your rights were in play, that much was real. But it refused to say that every street search needs full probable cause. Instead, it created a second, lower standard for a specific, limited situation. An officer, the court said, may stop you if he has reasonable suspicion, backed by specific facts he can name, that criminal activity is afoot. And if he reasonably believes you are armed and dangerous, he may frisk you, a pat-down of your outer clothing, for the narrow purpose of finding weapons that could hurt him. Not to hunt for drugs. Not to go fishing for evidence. To make sure you can't kill him while he checks out what he saw. That's the trade. In exchange for a lower bar to act, the search is kept small, a surface sweep for weapons, and nothing more. The court looked at that detective on the corner, watching men rehearse a robbery, and said, no, he did not have to wait to be shot. His stop was reasonable. His frisk was reasonable. The gun stayed in. But here's the part that should unsettle you a little. In solving one problem, the court handed police a tool far bigger than one corner in Cleveland, a key that fits millions of encounters, and it turns on a phrase most people have never had explained to them. So what is reasonable suspicion? This thing that can get you stopped and patted down without probable cause, without a warrant, without an arrest. Start with what it is not. It is not a hunch. An officer cannot legally stop you just because he has a bad feeling, or because of how you're dressed, or where you live, or the color of your skin. The court was blunt about this. An inchoate and unparticularized suspicion, a vague gut feeling, is not enough. What the law demands is specific and articulable facts. The officer has to be able to point to concrete things he actually observed and explain, in words, why they added up to suspicion. Men pacing a store window a dozen times and conferring between passes, that's articulable. It's a fact he can describe and a court can weigh. But reasonable suspicion sits lower than probable cause. Probable cause means it's reasonably likely a crime occurred. Reasonable suspicion just means there's a specific, reasonable basis to think something's wrong and worth a closer look. It's more than a guess, less than proof, a middle zone the law carved out on purpose. And that middle zone is where you live every time you're stopped on the street. The whole question of whether an officer can lawfully put his hands on you comes down to which side of that blurry line your moment falls. Now the part that protects you, because this ruling has limits, and knowing them changes everything. A frisk is not a search. Read that again. When an officer frisks you under this rule, he is allowed to pat the outside of your clothing, feeling for the hard shape of a weapon. That's it. He is not automatically allowed to reach into your pockets, open your bag, or dig around for whatever he can find. The purpose is strictly your capacity to hurt him, weapons, not a general treasure hunt for evidence. If, during that lawful pat-down, he feels something that is obviously a weapon, he can retrieve it. Courts later added that if the outer feel makes the object's illegal nature immediately obvious, that can matter too. But an officer who feels something soft and squishy, decides to squeeze and manipulate it to figure out what it is, and only then pulls it from your pocket, that has been ruled to go too far. The stop itself is meant to be brief, not an open-ended detention. This is the difference the case built into the law, a lower bar to stop and pat you down, matched by a tight leash on how far that pat-down can go. Lose sight of that leash, and the exception starts eating the rule, which is exactly the fear critics have carried for decades. So here's what actually matters the next time an officer stops you on the street. First, they don't need probable cause or a warrant to briefly stop you. Reasonable suspicion, based on facts they can name, is enough. Second, they can only frisk you if they reasonably believe you're armed and dangerous, and that frisk is supposed to be a pat-down of your outer clothing for weapons, not a search of your pockets, your phone, or your bag. Third, the moment it stops being about weapons and becomes a hunt for evidence, they've likely stepped past the line this case drew. That line has been fought over ever since. Supporters say it lets officers protect themselves and stop crimes before they happen. Critics say reasonable suspicion is so soft that it has been used to justify stopping huge numbers of innocent people, disproportionately in certain neighborhoods, on suspicion that never held up. Both of those things live inside this one ruling. It gave police a real tool and, in the same breath, planted the argument we're still having about how that tool gets used. Because the deepest lesson here isn't really about one detective or one corner. It's that your rights aren't a fixed wall, they're a line, constantly negotiated between your freedom to be left alone and the state's power to intervene. This case moved that line. And it's still moving. So I'll leave the decision with you, the way the court once had to make it. A trained officer watches two men rehearse a robbery, stops them, and pats them down for weapons. No warrant, no arrest, just a suspicion he can put into words. Did he protect the public, or cross a line the Constitution was built to hold? And more personally, if it were you being stopped on that corner, where exactly would you want the law to draw the line between your privacy and an officer's safety? Tell me in the comments, because that's the argument this ruling started, and it hasn't ended yet.